want to welcome everyone to our annual criminal justice lecture. And this year we have the great privilege, particular pleasure to co-host it with Berkeley Law School. That makes me particularly proud, particularly pleased, since both Berkeley Law and Goldsmiths share common values, their commitment, their attachment to human rights, social justice, the rule of law. And so it's wonderful that we can put this event together in place. And I just want to start by thanking both Professor Andrea Roth and Professor Charles Weisselberg from Berkeley Law that were very keen to engage with us and to be part of this annual lecture and to deliver this annual lecture. I would also like to take the opportunity to highlight the importance of this moment, you know, the moment at which our annual lecture is taking place. So this is a moment that is marked by shared, by common outrage at the violence that we have witnessed in the U.S. Across different parts of the United States. And we simply want to communicate the message that we are willing to stand side by side and we empathize. Hopefully tonight's event offers an illustration of that, but that should simply be the starting point. We want to remain connected and we want to follow the discussion, and we want, as an institution and as a community of scholars and students, to do what we can to be part of that crucial conversation that we need to have about race and law and race and policing and the criminal justice system in this particular case. This is also a moment that is marked by the terror that we have experienced, I should highlight, vis-a-vis the apathetic approach that some governments have adopted in relation to COVID-19. This event concentrates on responses within the criminal justice system in the United States in particular to COVID-19. But I must emphasize that a number of commentators across Europe and in the UK more specifically are particularly troubled by the disregard, the obvious disregard to the right to human dignity. And I think questions relating to the lockdown and how quickly it, or how delayed it was in the UK come into question. Finally, this is a moment that is marked by significant concern about the impact of COVID-19 across the criminal justice system. The criminal justice system that is an environment that is inherently marked by brutality, by violence, by loss of dignity, by loss of constitutional and human rights. And so we need to consider the ramifications of COVID-19 in that particular context. We should also give consideration to law enforcement in the context of COVID-19 and a significant concern that has been expressed again by a number of commentators in relation to the loss of liberties that we risk witnessing, that we risk experiencing as states begin to develop their responses, including legislative responses to the pandemic. So, considering all this, I think it is vital, and it fills us with optimism that we are beginning to have this conversation, and that we are willing to have this conversation across cultural and institutional and professional divides. And tonight's, or today's, as far as California is concerned, this morning's event is a fine illustration, I hope, of that, of our appetite for this cross-cultural dialogue that is more timely than ever. Very quickly, again, to highlight the structure of tonight's event, So we will start with Professor Charles Weisselberg, who, from his part too, wants to highlight the importance of this moment, particularly with regards to the events surrounding the disastrous death of George Floyd. After that, we will have first Professor Andrea Roth, then Professor Charles Weisselberg delivering our annual criminal justice lecture with a focus on US criminal justice responses to COVID-19. Our visiting professor in law, Kirsty Brimelow QC, will follow and discuss some of these interventions with the aim of extrapolating from the US example lessons that we perhaps have to learn here, or things that we should, practices that we should perhaps avoid, and also to reflect on what was happening in the UK, since he's developed a very interesting activity, has written and engaged with these questions in recent weeks in multiple ways. Finally, we will have Dr. Leora Lazarus, Professor Lazarus from Oxford Law School, who is also visiting professor in law at Goldsmiths, whose intervention we will be having during the Q&A. With no further ado, Professor Charles Weisselberg.
Thank you very much, Professor Giannopoulos, Goldsmiths, Ms. Brimelow, my colleague, Professor Roth. It's a very great honor to be here. This is an especially difficult time in America. We face multiple related crises, a public health crisis, economic crisis, a crisis in racial justice, especially within our criminal law system. I want to start with the crisis in racial justice. The murder of George Floyd last Monday has finally led to a recognition broadly across US society that Black and brown people are policed and are at risk of violence from police in very different ways than white people. And one can and should fairly ask why that recognition has taken so long in coming to parts of white America. There's a long list of African American and Latinx people who have died at the hands of the police, including Philando Castile, who in 2016 was shot and killed less than 8 miles from where Mr. Floyd perished last week. But here we are, and people are in the streets in grief and in anger and in pain, and steadfast in the belief that change must come. And they're right, and it must. And at some point over the next few years, America will find a new normal. Former President Obama said last week that we have to create a new normal where, and I'm quoting, the legacy of bigotry and unequal treatment no longer infects our institutions or our hearts. I'll go further than the former president and be more specific. We can't be a country where minority communities are afraid of the police and suffer violence at their hands. We can't be a country that incarcerates African Americans at much higher rates than white Americans. We also, by the way, shouldn't be the world's leader in incarceration. We can't be a country where Black and brown people die of COVID-19 at the highest rates, and where low-income communities are both called upon to staff shops and essential services during a pandemic, but then also suffer the greatest economic and medical hardships. So our crises are related, and we have to treat them as such. So today, when we turn to the US criminal justice system during this public health crisis, we have to consider how to reduce racial and economic inequality rather than exacerbate it. And I hope that as we think about reducing prison populations to flatten the curve, we may also find that reducing incarceration benefits us all. Professor Roth will start and address particular aspects of the prosecution and adjudication functions. I'll spend most of my time on reducing mass incarceration in prison populations. Both of us will consider ways to move forward and address racial and economic inequality. And time permitting, I'll also turn a bit to regulation of police. Let me now turn to Professor.
Thank you very much, Charles. Thank you very much, Professor Weisselberg. This is much appreciated. And as I explained earlier on, this should only be the starting point. And there is strong willingness from our part to continue to follow the conversation and to engage with the community and your distinguished university, but more generally, be in conversation with the US. We will now move on to Professor Andrea Roth, who I would like to quickly introduce. Professor Roth joined Berkeley Law in 2011. She had spent 3 years as a Gray Fellow at Stanford before that point. And before that, she was trial and appellate public defender in Washington, D.C., which, by the way, is one of the areas where we have experienced significant violence, significant anger in response to the murder of Mr. Floyd. Andrea's research focuses on the ways in which fundamental concepts of criminal procedure and criminal evidence need to be theorized, reconceptualized in an era of science-based prosecutions. In 2019, Professor Roth was one of 4 recipients of Berkeley's Distinguished Teaching Award and has received many other prestigious awards for her teaching and research at Berkeley and other distinguished institutions in the US. Professor Roth, we are very privileged to have you deliver the first part of our annual lecture. Thank you very much for joining us for this.
Thank you so much. Thanks to Goldsmiths for allowing me to participate in this and at this critical time. And as my colleague Chuck Weisselberg said, I realized that we were originally going to focus largely on COVID, but I did want to take a couple of minutes to make a couple of points, albeit as a privileged white person, academic, about these issues related to police violence. So let's see if I can make sure that this is, if everyone can see this. Let me know if there's an issue.
Very good.
So I first wanted to say a couple of things, make a couple of observations about the social movement and the role of academics in looking at this issue. The first is that the social movements, including Black Lives Matter, talking about inequities in the criminal legal system in the US with respect to racial minorities, has largely focused on defunding the police and criminally prosecuting officers who kill unarmed people and disproportionately young Black men. I did want to take a moment to talk about the limits of criminal law in being a mechanism for reform in this area. My colleague Frank Zimmering, distinguished criminologist, has written the definitive book thus far about this, When Police Kill. And he talks about several problems with using criminal law to deal with this issue. One is that when a person dies at the hands of the police, often the officer's account may be the only one. Even if there's body camera footage, critical moments related to what the officer will claim is a reasonable response to a perceived threat will go unscrutinized because there may not be eyewitnesses to counter the officer's account. We also have robust self-defense laws, for better or for worse, in the country, coupled with ubiquity of guns in the US. Unlike the UK, we have 300 million firearms in the US. And so an officer claiming a perceived threat in a traffic stop in the US has a different level of credibility than in a country where firearms are not as ubiquitous. The department policies also offer cover. If an officer, in Minneapolis, at the point of this, of George Floyd's death, chokeholds and carotid restraints were not against department policy. And so if the officer can say, I was reasonably following department policy, there could be limits of the extent to which they can be criminally prosecuted. We also have a robust standard of proof in criminal cases. You have to prove beyond a reasonable doubt every element of the crime, and that is a very difficult standard to meet. I think with respect to the intentional murder charges that just yesterday were added to Derek Chauvin's charges, I think it's going to be hard for the prosecution to meet that standard with respect to intentional murder. You have coordination between prosecutors and police. Prosecutors rely on police officers in all sorts of cases, and there may be a hesitance, to say the least, to prosecute police officers to the fullest extent. And then juries. We have non-diverse juries in the US because of a number of laws and social factors, including not allowing people with certain criminal records to serve on juries. And so I think juries in the US already would be deferring to police officers, but to the extent that you have people taken off juries who might have direct experience with law enforcement and abuses of power, those folks are being taken off juries. So I think one irony is that academics have a lot to add, but the criminological research on police killings has largely been taking a public health approach and reducing police killings not through a large defunding effort or which may not be politically feasible in a large amount, but reducing police killings through certain changes, including changes to the rules of engagement and having clear rules with respect to dealing with suspects with knives, number of shots fired, shooting into moving vehicles, etc. Reducing interactions between police and citizens that are unnecessary. For example, traffic stops, decriminalizing various misdemeanors to the point where we just wouldn't have as many potential interactions for officers to say that they perceived a threat. So I just wanted to point out, there's a website, 8 Can't Wait, that lists 8 evidence-based policies that could potentially reduce police killings by, they claim 72%, but you can look up your city, and in Minneapolis, you can see that they don't ban chokeholds and strangleholds. It doesn't mean that if they did ban it, an officer wouldn't do it, but I think these are very concrete, realistic steps. I know even this morning, a number of police departments in the country have said that they are going to ban chokeholds in the wake of George Floyd's death. And I think as painful and divisive as the last week has been, particularly for African Americans in this country, I also think it's a potential for bipartisan efforts, at least for certain concrete reforms that will reduce police killings. And the harder conversations can follow. Okay, and I know I speak for Chuck as well. I'm very happy to talk more about this in the Q&A, but I did want to talk a bit about COVID as well, which obviously raises issues of race and class inequities in the criminal system as well. So I wanted to briefly talk about whether these challenges that COVID poses to the US criminal adjudication system are unprecedented, and I'll say that they are. Talk about bail and pretrial detention, the rights to speedy and public trial, grand and petty juries being trial juries, procedural rights during trial like confrontation, and then some final reflections on this moment in history. So are these challenges unprecedented? And we've had other challenges to the US system before, from the attacks on September 11th to the 1918 flu pandemic to Hurricane Katrina, Hurricane Sandy. A pandemic is different in that it's ongoing, and it stops certain proceedings from being able to be held at all if we have social distancing. This photograph is from 1918 in San Francisco, where they were holding court outside. This is before the days of Zoom. I'd much rather be outside in London right now than sitting in my living room. But so they found ways around this. What makes 2020 different? I'm going to say 3 factors. One is mass incarceration, which I know Chuck will talk more about. But the numbers in the system right now and the numbers of cases that are being processed because of just a vastly greater number of criminal offenses, a much greater emphasis on punitive policies and mandatory minimums and overlapping federal and state crimes and a number of other factors. The numbers alone just make this much more challenging to imagine halting proceedings or having different, having proceedings done electronically. We also, in the 1960s, the Warren Court under Chief Justice Earl Warren, a Berkeley Law grad, made a lot of the constitutional protections that we're going to be talking about, speedy trial, public trial, right of confrontation, all of these things, binding on the states, binding on US state governments as well. And so we have just much more constitutional litigation, and people have much more constitutional rights in state court than they did in 1918. And of course, we have technology. And so the existence of technological substitutes for what used to be live procedures allows us to think about having Zoom trials in a way that we wouldn't have a century ago. Okay, let me talk about pretrial detention very briefly. There is a huge bail reform movement underway in the United States, but still in a majority of states, we have a money bail system, which I believe that you have to a lesser extent in the UK, but it works a little bit differently, my understanding is in the US. So, in California, if you're accused of a felony, there's an actual bail schedule that you look to. This is Alameda County's, where we are in Berkeley, that tells you how much you have to pay to get out of jail, this presumptive amount. It's very, it's a blunt instrument, and it obviously disproportionately affects low-income people, which was one of the main critiques of it. You don't pay the full amount. You pay you could pay to a bail bonds person to put up the money if you could put up 10% cash or surety. So what's happened in the wake of COVID-19 is that the courts in California have set zero bail for misdemeanors and most low felonies. And so there was a large number of people who would have been detained who are no longer being detained. Just to give you an example, in the Los Angeles County Jail, 3,500 people have been released. And so part of that is people who are already in jail who were detained pre-trial who have been released on with respect to COVID concerns about their safety in institutions. The Federal CARES Act with respect to federal courts have said that detention hearings are going to be telephonic or video. So all over the country, including in state court, you're starting to have video and telephonic detention hearings. So notwithstanding what I just said about zero bail, federal and state judges largely can still detain people on dangerousness grounds. That also has a disproportionate effect on low-income people and racial minorities. So just give you an example of an empirical study that's been done with respect to immigration removal proceedings in the United States. There have been several studies showing that people are more likely to be removed if their immigration hearing is held online, remotely, rather than in person. So I think a big question for the system is it unfair to defendants to have telephonic or video pretrial detention hearings if it makes them more likely to be detained pretrial? And then, of course, we have a number of other factors that affect low-income people with respect to the decision of whom to let out, including that a lot of community services that were available, inpatient drug treatment, et cetera, now are not available because of social distancing requirements and shelter-in-place requirements, requirements that somebody be tested for COVID before they're allowed in drug treatment, requirements that somebody have, let's say, a smartphone that has location monitoring and Zoom. That all has a disproportionate effect on certain communities. And then, of course, we have a huge local debate. I'm sure it's a debate across the country of whether zero bail, letting out a large number of folks pre-trial, has led to an increase in crime rates. It's unrealistic to suggest that releasing a large number of, especially young people, from institutions, that no one is going to commit what is a violation of the criminal code. And so, of course, opponents of zero bail can point to cases where somebody has committed an offense while out. And so I think one interesting thing about this experiment that we're going through with decarceration is, can we intellectually realize that we may need to abide a slightly increased crime rate to achieve social balance and equity in other ways, getting people back into their jobs and with their families. I think the answer is we have to, but that's going to be a debate. Okay, public trial, right of public access. There's a Sixth Amendment right in the US Constitution to a public trial, and so that's explicit. There's also a First Amendment. The First Amendment, a right to free speech and press and assembly, has been interpreted as allowing the public and the press a right of access to court proceedings. What's the systemic values underlying this? Both it increases accuracy from the transparency. Actors act better when they think they're being watched. It allows the public to ensure that somebody isn't over or under punished in criminal cases. There are narrow exceptions. There's also state constitutional rights to this as well. There are narrow exceptions for compelling interests, but they have to be narrowly tailored. So this is a right that is pretty categorical and actually enforced. This was an issue back in 1918 as well. Spectators were barred because of pandemic concerns. Now it's binding on the states, and it's a larger national issue. So the federal courts have allowed public access telephonically. So, and just this week, they're starting more Zoom hearings. So if you wanted to, sit in on a couple of weeks ago, I telephonically sat in on a federal presentment, a federal detention hearing. But it's weird because the actors, the judge doesn't know who's on the call. And so even though I, as a member of the public, am able to scrutinize the proceeding, the judge doesn't realize who's in the courtroom in a way that they wouldn't in a live proceeding. Normally photographing and recording are prohibited, but those have been deemed to be consistent with the telephonic and video inclusion of other people. I did want to mention Texas. So Texas doesn't always make the news as being the most progressive on criminal justice issues, but they have a YouTube channel. Each judge in Texas now, you can see it on the Texas court website, actually has a YouTube channel, and you can go, Judge Shelley Dukes, this was a recorded detention hearing that you can just go online and see. But you can also see that as a criminal defendant engaging in such a hearing from the jail, it's hard to, it's potential, without a lawyer, by the way, it's hard to make your case, perhaps, in the same way that being in person is. On the other hand, there are safety issues for defendants, even being in a room where other defendants have been moments before with the viral load in the room. there are safety issues with holding hearings even telephonically and video from the jail. And so, you know, to my mind, that's an argument for greater widespread release of people, decarceration, pretrial, because there's really no, it's lose-lose for the accused. And it's hard to read people over Zoom, and it may be that you're, again, more likely to be detained. There is something about telephonic hearings that might ironically be more intimate and possibly more persuasive than in-person hearings. I've heard anecdotally from some lawyers that having a telephone conversation between somebody who's accused of a crime and a judge actually allows for an interaction that can be much more intimate and potentially fruitful. So I don't mean to suggest that technology is dehumanizing in this context across the board. I think it's complex. Just wanted to mention the right to an indictment. You know, the U.S. clings to grand juries, even though, so the Fifth Amendment allows you a right in a felony case in federal court to indictment by a grand jury. It's not binding on the states. But a grand jury is big, grand. It's got typically 23 people. And the way that it's done now, it's just inconsistent with social distancing. So the federal courts here in the Northern District of California, just this week, have announced that they're starting to hold grand juries again. And my understanding is, just from anecdotal reports, that they'll be using possibly like a large courtroom that they don't otherwise use, like to make sure that folks are 6 feet apart. But I think there'll be interesting questions about whether you get a fair cross-section of the population this way. There will be people who will be excused from grand jury service because they're high risk, because they don't get the notices, because they don't, even if they're not high risk, they don't want to risk being in the courthouse right now. And I think that's all reasonable. And I don't know if they'll be able to participate remotely, but I think that's just happening this week. So right to speedy trial, and let me make sure that I have enough time to just offer some final reflections at the end. So I may go a little bit quickly through some of these, but I just want you to know what's going on doctrinally with some of these things. So there's a Sixth Amendment explicit right to a speedy trial in the US. It's binding on the states. There are also statutory rights in federal and state courts. It's difficult to enforce the right to a speedy trial. And there are, you know, just to understand why it's an issue, many state and federal, basically everywhere in the country, there's been a moratorium on jury trials, typically through the middle of July at least, and then we'll see. But it could be an indefinite moratorium on jury trials in criminal cases. So why is this so difficult to enforce? Constitutionally, it's this sort of mushy, multi-factored test. And you basically have to show some amount of prejudice, and which can be difficult to show before trial. Judges can extend the statutory time in the interest of justice, which is pretty easy to do, and I think a pandemic would qualify under most courts' views. The other problem is that the remedy for a speedy trial right violation is dismissal of the case. It's not like if you get a trial in 5 years, that's a cure for the speedy trial violation. So another problem is that courts are very reluctant to find a speedy trial violation unless they absolutely have to. And defendants, it's often in the defendant's interest to acquiesce in delays. It may be the defendant right now doesn't want a jury trial precisely because they're worried that juries will be concerned for their own safety and hold it against the defendant that they're being brought into the courthouse. And so it could be that, and they don't want a Zoom trial. So it could be that the defendants themselves, you know, the best remedy they could get would be release before trial. Still, some claims seem strong. There was a speedy trial claim in Sacramento, which is the capital of California, just last week that was denied by a judge, but it was, I think, pretty strong. It was somebody who was accused of drunk driving. It was a very simple open and shut case that would only require a police officer witness and the defendant's testimony, and could be done with, arguably with social distancing the same way that they're doing the grand jury. So one interesting issue that's raised by all of this is what happens when it's the defendant who wants the trial to go forward. It's the defendant who wants trial by judge, let's say, tomorrow. It's the defendant, defendants in the United States don't have a right to insist upon a non-jury judge trial. One question is, how much should defendants be able to waive? How much are these rights for the benefit of the accused or for the benefit of the public to have their cases adjudicated in a particular way? Really quickly on right to jury trial itself. This also was an issue back in 1918, and the flu halted jury trials. Again, the right to jury trial wasn't even a binding right in state court until the 1960s. So this is so much more of an issue now. There was a non-binding jury trial over Zoom, again, in Texas a few weeks ago. And aside from a juror, being on the phone for a while, the reports were that it seemed to be possible, but it was non-binding, so the stakes were low. There has not yet been a binding jury trial in the United States over Zoom. They're doing, in terms of live jury trials, the only place I know of that's really ready to go is Montana is going to have jury trials in huge gyms like this big. Allegedly, that's a gym, to make sure that folks are 6 feet apart. But again, they're going to be huge issues. A gymnasium, a gym. My husband's pointing out that it's possible that a gym is sort of a U.S. term, a school gymnasium where people would otherwise be playing basketball. So what's wrong with Zoom trials and what's wrong with live trials? It may also be lose-lose. With Zoom trials, can a jury meaningfully assess the demeanor of witnesses over Zoom? Can you get a fair cross-section of jurors if they need an internet connection? What about issues if the internet connection is lost? Will there be a mistrial? Enforcing rules of jury behavior. Sequestered juries would be impossible. In terms of live trials, you also have issues of safety of jurors, whether you get a fair cross-section from the community, who's going to want to show up, and is it scalable? So those are issues that we're dealing with this week, and this is sort of an issue in real time. Okay, 2 more things to mention briefly. First is a right to be present and to consult with counsel. So this is something that I think cuts both ways with respect to low-income defendants. It might be that this is an interesting opportunity to make many court proceedings, including a lot of status hearings, much more convenient for people who are accused of crimes and their families, who otherwise have to take off work and rely on unreliable bus schedules to get to court. And if they don't get to court on time, they could pick up a new criminal charge based on a failure to appear. So it's, in some ways, the absence of live proceedings and the ability to do some of this telephonically or through video might very well be helpful to low-income folks. At the same time, as I've mentioned, there may be issues with getting a fair shake in front of a judge over Zoom, and being able to consult with your attorney. You just can't replicate over technology the ability to whisper in your lawyer's ear or your client's ear in a way that you can in a live proceeding. Last thing on right of confrontation, which is sort of my own research interest. The Sixth Amendment gives a constitutional right of the accused to be confronted with the witnesses against him. That's all it says. It's not obvious exactly what that means, but the Supreme Court has seen it mostly as a trial right, mostly as a right at trial to both cross-examination and physical confrontation. And that's sort of a pretty narrow conception of what confrontation might be. You could imagine that confrontation might be a broader, more robust right to be able to scrutinize the government's evidence. That's not how it's been construed. It's been construed very much through this live testimony, look me in the eye when you say that, sort of way that arguably the Anglo-American system borders on fetishizing cross-examination. And so, you know, Justice Scalia, before he died, in a dissent in one of these cases that allowed one-way video testimony, said virtual confrontation might be sufficient to protect virtual rights. I doubt whether it's sufficient to protect real ones. So I'll just say, happy to talk about this more in the Q&A, but I think that there are so many other ways of thinking about confrontation that this moment might help us think about. Both machine witnesses that can't be cross-examined, but we could examine their processes through source code, et cetera. Allowing pretrial access to witness statements in order to impeach folks with inconsistencies, which there currently isn't a constitutional right to. Learning more about procedures like eyewitness identification procedures, much more helpful sometimes than cross-examination, and proficiency testing results for forensic experts. All of those things, more types of discovery other than cross-examination at trial. You know, if the mission of the confrontation clause is a practical concern for the accuracy of the truth-determining process, then it might be that this is an interesting time to think about a broader right of confrontation. So last slide, and then I'll hand it over to Professor Weisselberg. I think COVID has caused serious compromises of bedrock procedural rights and laid bare many of the inequities of the system, but I think there may be silver linings in terms of experimenting with decarceration, considering whether some technological substitutes are worth keeping post-COVID, and recognizing the broader purposes underlying certain rights like confrontation. Thanks.
Thank you very much, Professor Roth. Thank you very much, Andrea, for a very comprehensive picture of the U.S. criminal justice response to COVID-19. Already your presentation has sparked some really interesting questions. There's a particular focus on jury trials. The question is asked about judge-only trials. Has this been considered in the U.S.? There has already been considerable debate in the UK. My colleague at King's, Hannah Quirk, has asked the question, and she's written the Times to respond to the proposal, raising a number of concerns. I would say that this question is also particularly interesting from a continental law, or from comparison with a continental law perspective, given that there we're obviously much more familiar with judge-only trials. I think a connected question to consider is whether COVID-19 more broadly might offer an impetus, might trigger a change in the criminal justice system. In other words, has COVID-19 unearthed, brought to the surface any particular flaws in the US criminal justice system that we should perhaps try to amend, to fix when searching for a new model post the pandemic. And also there was a particular question about the Singapore court, the judgment that through Zoom imposed the death penalty. And that, of course, you know, is extremely, or sounds extremely problematic. I don't know the detail, but that sounds extremely problematic. So I think we will move to Professor Weisselberg, but in the meantime, please consider the questions, and I think you have access to the chat as well, because other questions may have already been asked. But once again, thank you so much for delivering this first part of our annual criminal justice lecture. It's a real privilege to have you here.
Thanks.
And with no further ado, I will quickly introduce Professor Weisselberg, who joined Berkeley Law back in 1998. He served as the founding director of the clinical program there, and it's a world-leading clinical program. I've seen that from close enough. It is a very impactful program, and students seem to hugely enjoy being part of that and making a difference, you know, from year one or year two in their program. He developed and administered that program between 1998 to 2006, and then made other major contributions to Berkeley Law. He served as Associate Dean for the JD program between 2013 and 2015, and then was the Associate Dean for the Advanced Degree programs at Berkeley Law. Charles' CV or information on the webpage is long and very detailed, and it would take me significant time to go through all that. But to cut a long story short, I would say that Professor Weisselberg is one of the foremost experts in constitutional criminal procedure. Professor Weisselberg, we're privileged to have you here and are very much looking forward to your contribution.
Thank you very much, Professor Giannopoulos, for your much too kind introduction. So Professor Roth had focused on ways in which people come into the criminal justice system and may be prosecuted or sent to prison during the COVID-19 crisis. I want to focus more on people who are already within the prison system and how they may be released and what lessons we might learn for rates of incarceration and reflect on the mass incarceration that has marked the U.S. criminal justice system. And I want to talk about releases of people and incarceration, also with a mind to racial inequality in America. But before turning to that, I just want to make one small point. Professor Roth spoke a bit about the limits of the criminal law in prosecuting officers who have engaged in violence against unarmed people, and she's right in that it's been very difficult for prosecutors to bring criminal charges against officers, even when there is video evidence that seems pretty clear. I mentioned Philando Castile's case in Minnesota, the killing that took place 4 years previously. The officer involved in that case was prosecuted but was acquitted. The thing that's remarkable this time, at least to me, is that I have not heard law enforcement officers back the officers who are charged now in the killing of Mr. Floyd. And police unions even have denounced the officers in that case. That's really striking to me, and I have not seen that before. And so I wonder if we are at a particular point in time where criminal sanctions may be more possible and where reform may be more possible. Let me now turn to mass incarceration in our correctional systems. I think one essential point to make is that the U.S. does not have a single criminal justice system. We have a federalist system. We have a federal government and federal police agencies and a federal Bureau of Prisons that houses people convicted of federal offenses, but primarily the law enforcement power resides in the states. And the states have their own correctional systems as well. So we really have over 52 criminal justice systems in the United States, which makes it quite challenging to think about developments as well as to think about methods of reform. So let me share now some data. I want to start with incarceration in the United States pre-COVID. I want to talk about infection rates. I want to talk about movements in the states and in the federal systems to release individuals. And I want to reflect on what lessons we might learn with respect to mass incarceration. So first, let me just say, what do we have in the United States before COVID-19? The last data are from year-end 2018, and these are people serving prison sentences of a year or more. They're in prison facilities, not jails. These data do not include individuals in jails. You know, over 1.4 million individuals serving sentences of a year or more. In the federal system, roughly 180,000. In state facilities, 1.285 million. So you can see that state facilities really dominate, state criminal justice systems dominate when you think about what is the criminal justice system or systems in the United States and what are the correctional systems. I want to look to some of the demographics. So let's take a look at incarceration rates. And these are the number of individuals incarcerated per 100,000 adults in each demographic group. For all adults, about 555 per 100,000 are incarcerated serving sentences or a year or more. This is as of year-end 2018. If you look at white adults, it's 268 per 100,000. For African Americans, 1,501, which is roughly 5.5 times the rate that we've incarcerated white adults. And for individuals categorized as Hispanic, also significantly higher than white Americans. A figure that has really struck me is in looking at males age 18 and 19. And as of the end of the year 2018, the rate of incarceration, again for felony offenses serving sentences of a year or more, is 12 times higher for Blacks in that age group than for whites. So the racial disparities are remarkable. I don't think incarceration rates are the full measure of a criminal justice system, but when one sees disparities of this nature, it really is remarkable and hard not to pay attention to. The Sentencing Project, a nonprofit within the United States, says that if you take a US resident born in the year 2001 and ask, what are the chances that that person will be incarcerated during their lifetime? For white men, the chances are 1 in 17. For Black men in America, it's 1 in 3. Now, we have the highest rate of incarceration in the United States among other nations. And, but there has been some movement over the last few years toward decarceration that I would like to note. In the state of California, where I reside, there have been significant reductions in prison populations, though they've been forced by lawsuits about overcrowding and the ability to provide medical and mental health care to individuals held in state facilities. In the federal system, we've seen some real improvements in the last few years in a number of respects. A series of laws have passed our Congress, the Fair Sentencing Act, First Step Act, Second Chance Act, all have different names, but collectively they accomplish roughly a same goal, which is allowing for the reduction of some federal criminal sentences, easing the severity of sentences for offenses that previously triggered rather high mandatory minimum provisions, and a chance to reduce sentences of many people convicted of crack cocaine offenses prior to 2010 during the excesses of our war on drugs. And those individuals were disproportionately Black. If you look at our prison population in the federal system, so these are people in custody for federal criminal offenses, the peak year of incarceration was 2013 with 219,000 people held. At just the end of last year, 2019, that had been reduced to 177,000. And today we're down even further. And that's a result of some of the releases. It may be a result of fewer people coming into the federal criminal justice system during the pandemic. But before we congratulate ourselves too much, I just want to note in 1980, the number was 24,000. So even though we have come down in the number of people we hold in at least the federal criminal justice system, you can see how the US became real believers in mass incarceration over the last several decades. I want to just note a couple of reforms that have been ongoing. The First Step Act, which was passed in 2018, allows a person in federal custody to ask the court for compassionate release for extraordinary and compelling circumstances. And there are a number of reformers who were making progress even since 2018. One important development was a bipartisan group with many stakeholders called the Council on Criminal Justice that was formed to build some consensus on solutions and progress. And I'm going to come back to that shortly. Let me now touch on infection.
I'm terribly sorry to interrupt you. We seem to be having some extra background noise. Perhaps you have some notes close to your microphone there.
Is that any better?
Yes, that's very good. Thank you.
Okay. So infections and COVID-19 in prisons. I'd like to turn to that briefly, and vulnerabilities of individuals. So as of yesterday, if you just look at the federal system, there were 1,956 people in Bureau of Prison custody who are currently COVID-19 positive. That does not include the several thousand who have recovered. Nationwide, as of about a week ago, over 34,500 inmates tested positive, with hundreds of deaths. The numbers vary widely among state correctional facilities, but it's very hard to track for some of the same reasons that we don't have accurate rates and numbers in our states and among the civilian populations. Ohio has the highest number of reported cases of COVID-19, but it's tested fewer than 20% of its incarcerated people. Michigan has a high number of reported cases, but it's tested over 95%. So it's very difficult to get the numbers. If you just want to look at some vulnerabilities based upon age, nationwide, and the Bureau of Prisons is similar to this, about 20% of the prison population is age 50 or older. About 3% is 65 or older. 3% may not sound like much, but given the numbers we incarcerate, it translates to roughly 40,000 people. And in testimony on Tuesday, the director of the Federal Bureau of Prisons said that in their first cut at identifying at-risk people, the Federal Bureau of Prisons identified at least 27,000 of its inmates with at least one COVID-19 risk factor. So what's it like in prison in a pandemic? I want to quote Rick Ramish. He was the former head of the correctional systems in Colorado and Wisconsin, and he made a statement in litigation in California at the end of March. And he said, among other things, due to the rapid spread of this virus, it's too late to debate and too late to litigate. In most states, including California, given current population levels, social distancing in prisons isn't feasible. There are large dining rooms, dormitories, cells with multiple bunks, and they're all settings in which distancing is extremely difficult and not impossible, even in super maximum security prisons. If governors and legislators are serious about flattening the curve, inmates need to be released to allow for social distancing in prisons and to ensure that medical staff have fewer people to treat. He called full prisons factories of disease by their very nature. And in the Tuesday testimony that was given by BOP director, Bureau of Prisons Director Michael Carvajal, he agreed prisons are not made for social distancing. Okay, so what can prisons do and what have they done? That's the next topic. In the state systems, I have much less to say, only because we have 50 different correctional systems and it's so difficult to track what states are doing. All states have a pardon or clemency process that's theoretically available, though structured differently. Sometimes a governor has exclusive authority to commute a sentence and release a person. Sometimes that power is shared between a governor and an administrative board. Some states have release by another process, but all states have that in place. There are court processes, and there have been lawsuits in many, many states against prisons. Sometimes these are class actions challenging the detention of individuals in a facility as a whole, sometimes with a claim that holding people under these tight conditions in a time of pandemic violates the Constitution. And a main claim that's made is it violates the 8th Amendment against cruel and unusual punishment, because by failing to keep vulnerable people safe, prison officials are being deliberately indifferent to their medical needs. And in California, there have been hearings in the long-running conditions cases that we have had. Data are hard to come by. UCLA Law School has a website that is collecting information along a range of different variables. And as of about a week ago, they reported over 24,000 releases from state and federal institutions, but these are only among some of the jurisdictions, so it's quite difficult to see what's happening. Let me turn to the federal system, because at least it's a single system and I can describe it more completely and give an update more thoroughly. So what are the various mechanisms to reduce federal prison population? There's first presidential power. It's the power of the president to pardon individuals or commute a sentence. There is compassionate release. There's a federal statute that allows a sentence reduction. This is all for people only in federal, not state custody, but for extraordinary and compelling reasons. The Bureau of Prisons can initiate this process by filing a motion to reduce a person's sentence, including the time served. And the First Step Act that passed in 2018 allows individuals in custody for the very first time to bring a motion in court. There's also transfer to home confinement. This is not release from custody, but it's a transfer in custody, allowing an individual to serve their sentence either at home or in a residential facility. And the CARES Act that Professor Roth referenced, that passed in March, has relaxed the criteria to allow greater numbers of these transfers. Then there are lawsuits. There have been habeas corpus petitions, class actions seeking injunctive relief, and there's congressional action that may reduce populations. So how have these worked? First, actually I should go back and say the first thing I mentioned was presidential power, but we have not seen any pardons or commutations since February 18th, before the pandemic was acknowledged in the US, much less in prisons. So we have not seen this president use his power to release anyone for COVID-19 reasons. What about compassionate release? So we've seen very few motions by the Bureau of Prisons itself to initiate compassionate release, but in the recent 2 months, floods of motions by individuals who have sought compassionate release. Often there's a question of whether it's timely. The statute requires an individual to first ask the Bureau of Prisons to initiate a motion and give the Bureau 30 days. And so some courts have been waiting and finding that motions are untimely filed even during this pandemic. Courts that consider whether to grant requests for compassionate release, in addition to the offense, tend to focus on the individual's risk factors as well as their plans for release. But you have to ask, who is it who's in custody who has an ability to provide a release plan with stable housing, family support, and employment? And I think one might suggest that it's disproportionately people with needs, and it's not low and middle income people, communities of color who are struggling with housing and unemployment. So I'm concerned that we are not putting forth resources for transitioning people who are at risk, but who need housing and could otherwise be released to home and community confinement. And if we want to address racial and economic inequality through compassionate release, we need to devote additional resources here to reentry. So what about home confinement? The Bureau of Prisons' preference is for home confinement over compassionate release. It's easier for the Bureau to administer. It doesn't require a court process, and the Bureau considers it a transfer in custody rather than release. Attorney General Barr has issued 2 memoranda to guide the Bureau of Prisons in transferring people and in setting up criteria for release or transfer to home confinement. The Attorney General has said that people in a few facilities where there are rampant rates of COVID-19 should be given priority. Individuals must have a verified or verifiable release plan. Public safety has got to be considered first and foremost. And in considering whether or not an individual can be sent to home confinement consistent with public safety, Attorney General Barr has directed the Bureau to use an instrument called the pattern instrument. It's a risk assessment tool, a fairly new one, to see if they score a minimum risk rather than some perhaps elevated risk of low or greater. Pattern is a new assessment tool that is still under development. It was developed in part following the First Step Act, and it has been challenged as relying on factors that are correlated with race. When the first iteration of Pattern was announced in July of last year, it was reported that 30% of white males in federal custody would be assessed at minimum risk, compared with only 7% of African American males in custody, in federal custody. After that was reported and there were questions raised about that and about the variables that go into pattern scores, Those who develop pattern claim that they have taken out variables that are correlated with race. And a second report about pattern was issued in January of this year, but those who reported on pattern did not report data with respect to scores and race. So we still have a question of pattern being used to screen people for home confinement, with the Attorney General insisting that priority be given to people only who score minimum risk, not even low risk. And what else has been happening in the Federal Bureau of Prisons? Even where people are approved for release, they've been placed in 14-day quarantine before being sent to home confinement. So the Bureau has, in particular places, created units within prisons for individuals scheduled for release to go through their 14-day quarantine period. But as new people go into those units, if any of them test positive, the Bureau has taken the position that the 14-day period must begin anew for everyone in the unit. The Bureau has claimed that it's transferred 2% of the population to home confinement, but these data are hard to come by and difficult to see. And when one looks at a reduction in federal prison population over the last month, it's hard to tell whether the reductions are due to transfers out or to a slower rate of transfers in. Let me just say, with respect to class actions and litigation, there's been very significant litigation in federal courts with respect to the safety of individuals in federal custody and efforts to release them. There have been orders entered by several courts that, that in a couple of high-risk facilities, like in Danbury, Connecticut, Elkton, Ohio, that the Bureau of Prisons should identify people who are at risk and screen them immediately for transfer to home confinement or for recommendations for compassionate release. Even though an order was entered on May 12th in the Connecticut litigation, at Tuesday's hearing, that's Tuesday of this week, the Bureau of Prisons director couldn't tell the senator from Connecticut how many motions, if any, had been filed for compassionate release, or how many people had been released or approved for transfer to home confinement. If there's anyone interested in the litigation, UCLA has a COVID litigation spreadsheet on release and conditions of confinement. I confess I can't summarize the legislation for all of you. When I looked yesterday, there were over 570 entries on the spreadsheet. Let me just say that at Tuesday's hearing with respect to the Bureau of Prisons, Senator Cory Booker kept pressing Director Carvajal about the demographics of those released or approved for release. The director did not have data to provide, kept saying that he would provide them, but I think it's incumbent upon us all as we think about addressing racial inequality to ensure that we do not increase inequality by releasing those with means and not releasing people who would return to communities of color, or who come from communities of color. Let me also just say that there have been efforts made in the Congress as well, and so I want to point to some legislation. And there are several pending bills that may provide release and relief, and that may point a way forward. There's the HEROES Act. This is the House bill with COVID round 4 stimulus money. It addresses some issues of compassionate release. It has a limited amendment to the First Step Act. There is an issue that's near and dear to my heart and that I've worked on, and that is that even the First Step Act, which was passed in 2018 and provides a route to court for someone in federal custody to ask for compassionate release, that act has been construed by the Bureau of Prisons to apply only to federal inmates who were sentenced for offenses after there was a huge change in federal law in November of 1987. So it's been held not to apply to people whose offenses took place prior to 1987. And we still have several hundred people in custody under what we call the old law. And so the HEROES Act contains a technical amendment that would address that. There's also the Emergency Grace Act, a Senate bill that has more fulsome measures that would address compassionate release most broadly and home confinement most broadly. and also contains this amendment to bring old law people within the terms of compassionate release. And I think that that's a really important and significant change that Congress will do going forward. So finally, this is sort of where we are. And I've already said some things that I think we need to do, particularly to address issues of racial and economic justice. I've suggested that we need to continue to place pressure on prisons, executives, and legislatures to demand a reduction in prison population for safety, and also to do it in a way that pursues racial and economic justice. We need to, as Senator Booker did, continue to push for data on demographics. We need, I think, to devote additional resources for community placements so that release is not only for people who have a demonstrated place where they can go and live if they are released, but we need to provide for release for high-risk people who need some help in finding places where they may go. We need to review instruments that assess risk and that are being used by decision makers. And given the huge risk to lives inside, I think we need to broaden the categories of those who are eligible for transfer or release. Professor Roth said that we have to understand that there may be some impact on crime rates. And I think we have to understand that. But I think we also have to expect that there are going to be changes in crime rates in the United States writ large as we move to 15 and 20% unemployment, and as individuals' housing and such become more and more at risk. Let me turn lastly to the Council on Criminal Justice, this nonprofit I referred to earlier. It had a task force on federal priorities and issued a report just last week. And I think some of its recommendations are even more salient in a time of COVID-19. And it issued some recommendations for lowering sentences, as well as some for increasing the success of individuals who will re-enter society. On lowering sentences, there was a recommendation of eliminating mandatory minimum provisions for drug offenses, and also allowing courts to take a second look at sentences down the road after individuals have been in custody and have served a number of years of their term. There are also a number of recommendations that I think are important to increase the success of individuals who will re-enter society. One is expanding public housing access for individuals with convictions. Currently, there are barriers about people with convictions getting access to public housing. Another is restoring educational grants and expanding education in prison so that people may be released better prepared to be contributing members of society. And a third set of recommendations, since the US doesn't have the National Health Service you have in the UK, is to improve medical or mental health care for releasees, largely through expansions of Medicaid. And a final recommendation is to oversee and provide much greater and meaningful oversight to the Bureau of Prisons, something I completely agree with. I just want to end by saying, look, it's imperative for public safety and other reasons to release people now, but we've been in an era of mass incarceration, and this is a time when we can think about, yes, we need to make these reductions, it's imperative to make them now, but I think we should also ask, as we are releasing people, did we need to have them in custody in the first place or in custody for so long? And I hope that this effort of releasing individuals may be a demonstration that it's possible to return people to society and not take people from society and rely on incarceration to the degree that the United States has done over the last several decades. Okay. I have some comments I can make on policing or policing in general, but I'm also happy to hold them for the Q&A.
Thank you very much, Professor Weisselberg. We are delighted that you have delivered the second part of our annual criminal justice lecture. You have brought to the fore the close connection that exists between race on the one hand and issues inherent in responses that we need to provide to COVID-19, including through the criminal justice system. And then the final point that you made just now about the way forward and how we need to consider whether we need to have people incarcerated in the first place. I think that responds to one of the questions that were made earlier on about how we move forward and what lessons we learn from the pandemic. And I think what you've just said, you're showing the way forward. I think it's a good time to move on to comparing and contrasting, to highlighting some of the key concerns that have been expressed as far as the UK response to COVID-19 is concerned, including in relation to law enforcement, including in relation to criminal law enforcement. And so I have the unique pleasure of introducing to the panel my colleague and her visiting professor in law at Goldsmiths, Kirsty Brimelow QC. Kirsty is one of the leading criminal law and human rights experts in the UK. She is the head of the International Human Rights team at the Doughty Street Chambers, a leading chambers in UK, and has again won several awards for her pro bono work and for really going the extra mile and supporting vulnerable individuals and individuals in need. Kirsty, it's a pleasure to welcome you to the panel. Thank you very much for your contribution tonight.
Thank you very much. I'm going to start actually with primarily these are the words of a barrister, a colleague of mine in Chambers, a black barrister, and he actually emailed around all of us, including all the staff, with his thoughts and feelings and frustrations and tears and pain at the killing of George Floyd. And what we've then done is we've basically taken what he said and we've put it now on our website in Chambers. I'm just going to read it. And it's this, we stand with black and minority communities everywhere in condemning the racist and unlawful killing of George Floyd and the institutional racism and wider systems of entrenched inequality in the US, the UK, and across the world. Doughty Street Chambers has a proud history of fighting the origins and the manifestations of abusive power. We're proud of our history, our members, and all we achieve or try to achieve in challenging racism and the abuse of police power. Yet we realise we should not sit on our laurels. Human rights lawyer does not provide immunity from the pernicious reaches of structural racism. In fact, in some instances, it provides a cover. We work to address discrimination in our professional lives, but acknowledge that our everyday lifestyle choices and priorities are no less important. We pledge to confront racism in our society and in our lives. We make this pledge to do what we can because we must. And hashtag Black Lives Matter. We, all of us, have reflected really on our daily choices and as well as the work we've done. And I'm always very grateful for the kind introductions that people like Dimitris make. But I think all of us probably at times like this are maybe reflecting on our own choices, what we do every single day. And in fact, before this panel started, we were having a discussion about that. In fact, it's a white panel, for example, and I know that Dimitris is going to speak about that. But everything we do, we perhaps should check ourselves, those who are in the position to do that. So that is just what I wanted to refer to, and I continue to watch what is happening in the US and also what's happening in the UK with that connection with the protests, because a lot of the work I've been involved in as a practitioner in probably the last 10 years actually has been protest cases. But for the time I've got this evening, and I'll open up to questions, I'm just going to touch on law and what it means. and also the rule of law. And then I'm going to look at our emergency laws in the UK, but concentrating on England with the emergency laws that we're subjected to. And I'll touch upon the case of Dominic Cummings, not specifically him as an individual, but how that plays into the application of law, and how that is actually important, that we don't lose a grip of that individual case. So Jeremy Waldron, an academic, a very well-known academic, describes the rule of law as one star in a constellation of ideals that dominate our political morality. So laws are necessary, for otherwise the rule of law doesn't function. However, they're meaningless if they're misapplied or if they're applied unequally. Now, we live in an unequal society, so part of this is striving for an ideal, but legal systems should strive for equal justice. The other aspect, important aspect of the rule of law is that it's accessible. And for example, Emperor Caligula reportedly wrote laws in extremely small letters, in tiny letters, that were on a tablet hung high up. So in fact, they could only be read by as fewer people as possible. Now that immediately would be a violation of one aspect of the rule of law, because it has to be clear and accessible. People need to know what it is. And this is one of the issues we've had with our emergency laws here, in that because we've had strong messaging from the government and guidance from the government, that's been mixed up with what the laws actually have been. And so we've seen, therefore, the police confusing what they considered to be laws, and they've actually been arresting people or subjecting people to criminal processes on the basis of guidance, which isn't law. So beware when people talk about rules, beware when people talk about guidance. We have law and guidance. Law obviously is binding, guidance isn't, and rules is just mashing up and confusing. So we really need to move away from this language of people breaking the rules as if we're all part of some national sport. Now the laws, the emergency laws, very briefly, we've got two sets of laws, and the one that we've all been concerned about here have been the health protection coronavirus restrictions regulations. Now, these are the ones in England. There were very similar regulations which were brought in Scotland, Northern Ireland and Wales at the beginning. However, as the England regulations have gone through various amendments, and they were amended on the 22nd of April, the 13th of May, and the most recently on the 1st of June, the differences have really grown between the regulations of the other three nations. What's important is that they are secondary legislation under the Public Health Control of Disease Act 1984. Why is that important? Because you look at the purpose of that act, which was introduced in summary to tackle the coronavirus, to protect people from the spread of the coronavirus. And so therefore the secondary legislation should be within that purpose, for it to be virus. If it's not there for public order. There also was a second piece of legislation which is called the Coronavirus Act. Now, many of you shouldn't have come across that, because that actually sets out powers for officials such as immigration officials and police to really support public health officials when they are dealing with somebody who is potentially infectious. And they have There's powers there for those who are considered to be potentially infectious, for example, to direct them and take them to a place of screening and assessment. There's then powers to keep them at that place of screening and assessment. And then there's powers after the treatment, after the assessment treatment, as to where they are. Now, what has happened in England is that there has been a sort of mashup between the public health regulations, which are the ones which introduce prohibition on movement and prohibition on gatherings and so on, the ones that we're all concerned with, and the Coronavirus Act, which really shouldn't really be used unless it's a situation with somebody who's potentially got the coronavirus. Now, the just moving very quickly through to therefore Dominic Cummings's case and why that's important. First of all, those of you who have followed the case might recall it was where he actually gave a press conference, which is pretty unprecedented for a government advisor, and where he set out that he had left his home because there were concerns that he might become ill with coronavirus, because his colleagues within government were becoming ill, that his wife, who'd been ill previously, although she seemed to have recovered, might become ill, and they had a 4-year-old child. And so for concerns about childcare, they decided to drive from London to Durham to stay on the farm of his parents. And this is about 260 miles. So that's it in general. Now, all well and good, that's the decision he took. However, the issue became, did he actually break the law or not? And the issue became heightened because people who had been abiding very strictly by these draconian laws, and they're the most draconian laws since World War II, they were concerned that they've made a huge number of sacrifices, and yet it seemed that those who were bringing these laws into force, advising on them, directing us what we should do, were really doing what they wanted. And so this started a breakdown in trust within the society. Why is that important? Because policing in the UK is policing by consent, and it's been touched upon. It's a very different type of policing into the US. And again, if we have time on questions, I think this is key, and it's been touched upon by the previous talks, in that force is not, we don't have armed police who we have access to armed police in particular situations, but we do not have armed police who are called out to something like a traffic incident or a fight or somebody drunk on the street, for something where there's no complaint that somebody might be armed or concern that somebody might be armed. Armed police aren't used. And so we have a consent policing, which involves cooperation, in that the police will say, I'd really like you to do what I'm telling you, and enforcement is supposed to be last resort. Now, back to the case of Mr. Cummings. In brief, the drive from London to Durham did not fall within any of the reasonable excuses which are under the regulations, under Regulation 6.2. And this list of reasonable excuses are non-exhaustive. They include, and the ones that were attempted to be relied upon, was to provide assistance or care, including relevant personal care to a vulnerable person, or to provide emergency care. This is, you could at that time go out to provide care for somebody who was vulnerable. So if he'd remained where he was and was considered, his child was considered to be vulnerable, it turned out that wasn't the position, but somebody could have come to him without any issue. But the whole guidance, which is separate, was if you have coronavirus, then you stay in. If you have symptoms yourself, self-isolate, 7 days. other people in the household 14 days from the time that that person starts the symptoms. So that was the situation. Eventually, Mr. Cummins settled on a paragraph of the guidance, which sets out that if you've got children, follow the advice to the best of your ability, and then not all measures will be possible. However, it's very clear that that referred to measures that were being advised within your home. For example, do online shopping, there's e-learning, clean as much as you can. And this was an attempt to recognise that not everybody would live in a very large house with 2 kitchens where they can distance each other, and not everybody actually would have access to the internet within households. And so there was a reassurance in that paragraph that Dominic Cummings relied upon, effectively, don't worry, children, so far we've seen that children with COVID-19 appear to be less severely affected. So don't worry if you can't have that kind of distancing or comply with this online shopping, etc., etc. So that was that. There was then the very well publicised incident, which you referred to, on the trip to Barnard Castle, which I won't go into because of time, but the Durham police there, just to be clear on their finding was he had broken the law. Now, the wording was a little confusing, but the finding was he had broken the law as far as they were concerned. Now, the police aren't judge. They don't make the decisions. He could dispute it and he could have taken it to court if he'd been stopped. But what they said was that if they'd stopped him, they would have had a reasonable belief that he'd broken the law. And what they would have done is that they would have encouraged him to go home. And if he complied with that, they wouldn't then have gone on to enforcement. Enforcement, next step, could be direction, go home. Step after that is issuing a fixed penalty notice, which is a way of diverting away from the criminal system. Step after that is, okay, we're now going to apply for or report that there's going to be a summons and that you're going to be prosecuted. So enforcement is the last resort. Now, just in conclusion, because of I know I want to leave it open for questions. Where are we with this? Why is this case important? It's not about politics. It's not about an individual. It's about equal application. Now, the law, the fixed penalty notices that have been issued, according to recent figures, has been 17,000 fixed penalty notices issued. And out of those fixed penalty notices of real concern, the statistics from the Metropolitan Police issued on the 3rd of June shows that 26% of the fixed penalty notices issued between March the 27th and May the 14th were issued to Black people, who make up 12% of the population in London. And so we can see a disproportionate issuing of fixed penalty notices to Black people, which is in itself concerning and requires more investigation. We have a point where I and a number of others had already written to the National Police Chiefs Council, to the head, Martin Hewitt, requesting, before Dominic Cummings' case, requesting that fixed penalty notices be reviewed. The reason for this was, you might recall, that we started to see a number of wrongful prosecutions of people under the coronavirus laws. And this led to, so I worked on a number of cases with the Times. This resulted in these convictions actually being set aside. They were wrongfully brought, and the prosecutions were wrongfully brought. And when the Crown Prosecution Service did a review, and it found that 28% of its prosecutions were wrongful prosecutions. And so these were cases that have finished at the end of April, so there might even be more. The CPS published the results of its review on the 15th of May. So where there's safeguards in a system, including a court, where there's lawyers, where there's a district judge, when we have that level of the law being wrongfully applied, you can infer from that where there's not an oversight of police issuing fixed penalty notices, there's highly likely to have been the wrongful issue of those notices in any event. The second part to that, post Cummings, is that there now is a call as well that there should be the setting up of a panel by the government to review all fixed penalty notices. And this is to use a discretion simply to set them aside by people who might have been in breach of the regulations, but where there should not have been a move to enforcement. That in fact, what the police should have done, as they said they would have done with Dominic Cummings, is just said, look, go home, some encouragement, all right, we accept this, but it's the middle of a pandemic. Can you perhaps now just change what you're doing currently? And we're starting to get a number of people coming through who have been issued fixed penalty notices, paid it because they don't want to risk challenging it in court and potentially getting a criminal conviction. And they're very aggrieved by it because also they were in a position of social distancing, they weren't in crowds and so on. So that's the second part of the call for the review. Why is it necessary? It's really necessary to restore trust, because otherwise, particularly with these draconian laws that we are following still, people will simply stop complying. And when you lose that cooperation, you're onto a road of a complete breakdown, not only in terms of cooperation with the police, but in terms of trust and faith in the courts and cooperation with the court system. So that is the call there. On remote justice, just very briefly, as we've been discussing that, I'm open to questions on that, because I've actually been representing a claimant in a judicial review on this was actually for a limited opening of a mosque remotely. So all the parties were had the hearing, a day hearing remotely. I've been defending in a case, a criminal case, remotely, and that was an extension of custody time, bail application. And I actually physically have been in a criminal court this week where distancing was put in place. So I can help with any questions on the practitioner experience in relation to that, but I'll leave it now and perhaps to open up for questions. And also finally, if anyone wants to know how the law has shifted on the 1st of June, I can give a very brief summary on that as well.
Thank you very much, Kirsty. I really appreciate how you've managed to bring the surface. I think that the difference of focus as far as the two legal systems that we are primarily preoccupied with in this event have dealt with COVID-19. So we've seen that in the UK, there has been very significant focus on enforcing the COVID-19 legislation in relation to the lockdown initially, and now more recently in relation to social distancing measures. And the question that immediately springs to mind is whether there has been a similar preoccupation with such cases in the US. I mean, I haven't come across similar high-profile cases, something similar to Dominic Cummings here. And also the fact that the Crown Prosecution Service have, for the first time ever, correct me if I'm wrong, Kirsty, but for the first time ever decided to review every single conviction in that particular area. Every single conviction for a COVID-19 offense was in itself quite striking. And as you pointed out, I think 28% of these convictions were wrongful convictions. So my immediate question to Charles and Andrea, Professor Weisselberg and Professor Roth, is whether such issues of enforcing the COVID-19 legislation, enforcing the lockdown, social distancing, have been a concern for the US legal system. And if not, why was that the case?
I would just add that, like in the Berkeley City Council, even our local government, there was an exchange the other night about how we don't need a curfew to deal with the protesters. We just need to use our shelter-in-place order and deal with the protesters under cover of the shelter-in-place order. So there's definitely a clear concern that it will be enforced for reasons not necessarily completely related to public health, and then of course, anecdotally, there are these comparison pictures all over social media talking about how, you know, certain groups, playgrounds in predominantly wealthy white neighborhoods are full of kids and grown-ups that are way fewer than 6 feet apart from each other. Again, I feel like the one main issue, just bringing COVID and George Floyd together, and of course, Mr. Floyd suffered from COVID, so is that it's about making sure that many of these so-called offenses are not considered crimes, or at least arrestable crimes to begin with, to reduce police-citizen interactions, to reduce the collateral consequences from arrest. And so I think there's, and to reduce the incentive to arrest for pretextual reasons. So I feel like the concern is not just, you know, do we make sure that each prosecution of what is considered a crime is valid or justified, but also, you know, why is this being dealt with by the criminal law at all?
Mm-hmm. Mm-hmm. I mean, that's a very good argument that played out a lot in the debate here in the UK. The idea that was defending was that it should be. I mean, the issue should be considered as an issue of public health. It shouldn't be for criminal law. And certainly the police in recent days, now that the lockdown regulations have been substantially relaxed, are quite openly saying we can no longer be held responsible for enforcing this legislation. First of all, because it's so complicated to enforce. You know, there's a lot of discretion that comes into play, and secondly, because it continues to put our relationship with the public into doubt, and trust is lost every time that we have these interactions. You know, going about trying to enforce legislation that sometimes concerns quite trivial conduct. You know, people being out and about, walking in remote places. In the UK, we had that originally. I mean, people would be in the Peak District, you know, going for a walk, and you had the local police using drones and then naming and shaming, posting the video, and highlighting those breaches. To the extent that a former Supreme Court justice that is otherwise quite conservative has spoken about the risk of moving quickly to a police state unless you know, we cut back from the police using such extensive powers. At this stage, I'd like to open the floor to discussion you know, between the panelists, or whether we have questions. If we have any questions from our audience, there is an interesting observation posted on the chat. So essentially, Jenny comments there are glaringly obvious links between impunity, abuse of power, lack of transparency and fairness, social, racial, income inequalities, and social injustice. And I think that came following from Kirsty's presentation, but it obviously pertains very well to the similar conversation that you are having in the US about inequality and enforcement of COVID-19. I don't know if there's any further reflection on that. There's also my colleague, also visiting professor in law here, Oxford's Dr. Leora Lazarus, Professor Leora Lazarus, who I believe would like to make a brief intervention. So Leora, if you can hear us, feel free to pop in.
Yes, hi, and thank you for great contributions over to Berkeley and for getting up in the morning, and thank you, Kirsty. I just wondered, I wanted to probe on this question of how the US conceives of protection of the right to life in the context of imprisonment. Now, in the UK and the European Convention on Human Rights space, we would look at this question through the prism of the idea that the state has obligations to protect life in the context of operational and systemic obligations flowing, which would have a particular impact on prisoners themselves. And I'd be really interested to know the framing of what might be potential litigation beyond the question of emergency measures for release of prisoners in this context.
Thanks, Leora. Tag?
Yeah, so let me try to address that. So there are a series, you're asking this particularly in the context of litigation, how the litigation might be framed. Let's say if it's brought by an individual inmate or an inmate's family, if the person has passed away due to the actions of prison officials and not keeping them safe or not releasing them if they're highly vulnerable and such. So again, with sort of a diversity of state and federal systems, you have 50 correctional systems in the states. So if this occurs in a state prison facility, if it's a state inmate, there may well be remedies under state law that could be brought in a state court, claiming that there's a statutory duty that was violated, let's say, by the prison officials and such. If it's a lawsuit in federal court, it would be under our civil rights laws. There are civil rights lawsuits that are brought in federal court against state prison officials commonly, and they have to allege a constitutional violation. And the main way of framing it is saying that holding them under these conditions or allowing someone to die under these conditions is cruel and unusual punishment. And the standard is one of deliberate indifference to the needs of the individual. So that's sort of the constitutional standard that would have to be brought. And that's also the way it would typically be framed for a federal inmate or the family of a federal inmate suing federal prison officials. There are, however, also doctrines that make recovery of damages in a civil lawsuit extremely difficult. These are doctrines called qualified immunity that essentially give great deference to officers and say that they won't be liable unless the law is clearly established so much that their conduct would have been known to have been impermissible, that a reasonable officer would have known they couldn't do what they did. So both it's sort of a high standard to establish a constitutional violation in the first place, and then second, doctrines of qualified immunity make it difficult to recover for damages or to find liability on behalf of or on the part of individual actors. Does that help?
Yes, thank you very much. I just can get a sense of what would be the sort of legal framework that officers would be operating in. But can I just ask one specific question? Is whether the point of release would be one that might be required as a measure to avoid a breach of standards in relation to cruel and unusual punishment, or whether other mitigating circumstances might be, or mitigating actions might be sufficient to effectively discharge that duty of care.
Yeah. So I think sort of both are possible. And in some of the lawsuits we've seen in the United States, we've seen a couple of very notable class action lawsuits that are sometimes framed jointly as a class action habeas corpus petition seeking release of an individual or their change in custody, combined with a request for injunctive relief to demand that prison officials do things like provide greater protections within a facility or engage in expedited processes to review whether someone should be recommended for compassionate release or home confinement. Of course, even in those instances, a prison official might say, well, they're just not eligible for X, Y, and Z reasons, or we've made them safe in another way. So I think both are possible, and the cases are just now going forward.
Great, thank you so much.
I would just quickly add, in the pretrial context, what federal public defenders are finding is there's a little part of the federal Pretrial Detention Act that's very infrequently used, that allows a judge to release someone or choose not to detain them, basically in the interests of justice or something that typically courts just wouldn't do that. And so defenders are using that, wielding that to try to argue sort of, not being able to necessarily make an Eighth Amendment claim or some other due process claim, but saying there's enough of a concern about this person's safety, that should be a reason alone not to hold them even on dangerousness grounds, even if all the boxes are checked. And I wonder post-COVID whether there will still be room to argue this on other grounds, like the high rate of sexual assault in prisons and jails, tuberculosis. I mean, it's not like it's a safe place anyway. So there may be a different way of viewing the role of safety of people incarcerated, even pre-trial, in arguing for release after this.
I mean, it's interesting that in that context commentators were originally expressing significant concern about the development, about the way in which the pandemic would develop in the criminal justice system, in prisons in particular. And yet I was looking at the statistics in the UK, and that has not necessarily happened. On the contrary, there was a very small number of deaths compared to what people were predicting anyway. But perhaps for that to have happened, people in prisons have been subjected to very cruel measures of spending very long numbers of a significant number of hours in isolation, and so I'm wondering whether that phenomenon was also observed in the States.
I think it varies from place to place. There are some prisons that are making great efforts to isolate individuals where that is possible, but the sheer numbers of folks held and the shape of housing units makes it extremely difficult to do that in an effective way and to do that uniformly. In fact, it may be that some of the most difficult facilities are those that are lower minimum security because they tend to be dormitory housing as opposed to housing in particular cells. And so I think the ability to do that and keep people safe is extremely fact specific, depending upon the numbers at a facility, the population level and such. But, you know, Rick Ramish, in his statement in March, the former correctional director, said, look, you know, even where you have a maximum security facility with single cellar and people in lockdown and solitary, you still have staff, daily contact with them, whether it's delivering meals, whether it's communicating with them about their health and moving from person in custody to person in custody. So even under those circumstances, you can't sort of isolate in a way that keeps you free from the risk of transmission.
Thank you very much, Chaka. I'm conscious of the time, but there is one other observation in the chat function that I'd like us to draw when coming to concluding observations, perhaps. And it touches upon, again, the issue of trust or the lack of trust, the mistrust between police and the BAME community in the UK or people of color in the US. And basically the point here is that this pre-existing mistrust between the police and those communities is the source of the problem. So how do we go about rectifying that fundamental issue? And are recent events an opportunity for normal? Do they offer an opportunity to review our practices? Is there any reason to be more optimistic?
I suppose I would say that, you know, this all presupposes that trust is the goal. And there are so many benefits that flow from trust. Having witnesses be willing to testify, increasing homicide clearance rates. But I think it will take at least a generation to change so many of the aspects of the system that are infected with bias, from what is deemed a crime to the sentencing structures that treat certain crimes differently, to enforcement means that target certain neighborhoods, to the the ways in which trials have disappeared. That's what I would talk about with respect to these judge trials. Is in some ways it's better than no trial, but until we get plea bargains that are not coercive and not conditioned on, that are not real bargains, that have systematic over punishment over time. Before we even get to policing practices, I don't think trust will be there. So I think that for the next generation, we focus on changing all of the policies that have exacerbated biases, and we focus on reducing police-citizen interactions. And to the extent that we defund the police, it's not defund the number of officers, it's demilitarize and get rid of the role of police officers in dealing with mental health crises and public health crises, and focus more on violent crime. That in a generation, we can talk again, I suppose, about that.
So not very optimistic, not for the time being. Zach, do you share that relative but evidence-based lack of optimism?
Unfortunately, I do. I do think it's a generation at least, and it's going to be change that's accomplished only if there's change in behavior of the police. I think that trust will only be developed even over time if there is demonstrable change in police behavior and in the way that there are interactions between officers and individuals. And I just think that's so difficult in the United States with 17,000 plus state and local law enforcement agencies. Forcing change or forcing changes of behavior without restructuring forces themselves or oversight of forces is happenstance, and it's just so difficult to accomplish in kind of a uniform way. I do think we need, as Professor Roth suggested at the very outset, clear rules for police rather than just vague standards for police, that may be a way to begin to change police behavior. I also happen to believe we need changes in some decisions from the Supreme Court that have given enormous deference to police and that have established doctrines like qualified immunity. But fundamentally, I agree with Professor Roth that it's going to take at least a generation, and that change still won't take place within a generation unless we see alterations in the way that people are policed.
On the question of uniformity, more specifically, Professor Weisselberg, what happened to the American criminal procedure revolution of the 1960s, where your distinguished alumnus, Judge Gerald Warren, has led on? Because that was the ambition, and that was the rationale, that was the starting point, the need to address racial inequality, particularly in the criminal justice system. And yet we have seen that the Supreme Courts that have followed did not show particular enthusiasm for continuing the legacy. Quite the opposite happened.
Well, you may be painting the Warren Court using a little bit too rosy a light or a picture in too rosy a way. I mean, it's the Warren Court that gave us some basic policing cases like Terry versus Ohio that allows officers to stop an individual with just reasonable suspicion they may engage in some activity, and to do a frisk of that individual on the street with some suspicion they might be armed in some fashion. I mean, some of the cornerstones of deference to police and some greater powers to the police were also established during the Warren Court era. So I don't want to look back too wistfully to the Warren Court era, but it's very true, as you say, that there have been retrenchments since.
Thank you. And on the UK side, Kirsty, Leora, going back to the question of trust, are there any reasons for us to be more optimistic? Yes, you have highlighted a number of concerns, Kirsty in particular, but on the other hand, we have seen that due to an engaged legal profession, due to very active NGOs in the area of criminal justice and human rights, the CPS has taken that quite dramatic step of reviewing all the convictions in relation to COVID-19. Are you feeling optimistic or not?
it's interesting actually comparing. I've been fascinating listening to the situation that is faced in the US and the comparison with the situation in the UK. I think with the criminal justice systems are in very different places, and the big struggle we have at the moment, because of actually the Cummings situation, is getting back to a position where you are not having one rule for those in power or close to power, and another rule for others in terms of the application of the law. And we had this a number of years ago when I think we've always failed here with bringing criminal cases against people in power, and we had the sort of MP's expenses scandal, which the CPS then did manage to bring a number of prosecutions, but whenever the serious fraud office, for example, has never there's been all sorts of massive cases which have collapsed. So I think that's we have a lack of parity in the application of the criminal law, and you see it tends to be the vulnerable people who are caught up within it, and enforcement goes against them. But that's a very different situation to excessive use of force, and the not having armed police makes a huge difference. And every time there is any escalation on use of force, so that there is a lot of pushback from NGOs. So when last year there was to be an increase in the use of stun guns, and they were to move to other officers, not simply the frontline officers. There's been a lot of debate around that. So I think we're obviously a much smaller country as well, and we also have had so that the inquiries do reach across the country. So I'm optimistic in that I think we've got a reasonable fairness floor, which is what we need, but we can't be complacent, and that's why it's important that where there are injustices, that we do use our courts as well as activism to push back against them. And I also say having a regional court is the European Court has been very important, and the access to the European Court of Human Rights has been very important in this country, particularly on right to life and also on behaviour of law enforcement. And maybe with the US, I've actually got a case looking at drone strikes in Yemen, and of course the United States isn't a party to the Inter-American Court, and then there's the limitations with the US engagement with the UN, and I'll be very interested whether anything can be done there. This goes back to oversight effectively for the UN to actually become a party, say, to a regional court on human rights, and whether that would make any difference.
Considering the approach that the current US administration has taken on international law, I think that's very unlikely to happen. I'm sure
it's going to be a long way off. Yes.
I'm sure you will agree with me. But on the note of the very useful point that you made about the European Court of Human Rights, I would like to again bring in Professor Leora Lazarus for a final perhaps observation in relation to the importance of the role that the court might have. This is very much about striking a balance between enforcing quite draconian legislation. I think we have all agreed with that. On the one hand, a legislation that has significant scope to impact upon individual human rights, constitutional rights, to use the US terminology, but on the other hand, protecting the public interest, protecting health in this particular case. How do you see these conversations panning out, Leora, in the months to come, in the years to come? And of course, we have the fundamental question of Article 2. And the question there is whether the UK government, for instance, could be held accountable for flaws in its response to COVID-19, be that in relation to criminal law enforcement or triggering the lockdown with significant delay in the first place.
Yeah, so I mean, I've just completed quite a long report in which on COVID-19 measures across 11 jurisdictions. We chose a small sample of jurisdictions and also looking at international human rights sources. And there is a growing body of law in international law looking at the different human rights safeguards. So I think the first part of this is going to be the question of what the clear balance might be between the right to life, the right to health, which is also a human right, the right of access to health, and questions of rights to liberty. I think the whole pandemic terrain is a question of how we prioritize and balance between those different rights and interests. And the dangers that we've seen across these different jurisdictions, and we haven't included the US, we were a little bit overwhelmed by the scale of what the US would be presenting. The dangers that we're seeing is as follows. The first is a downgrading in democratic accountability and a downgrading in legal specificity sufficient to allow review. And this taps into something you were talking about, Kirsty, about the relationship between guidance and regulations being very complicated. But we also saw a particular overuse of the criminal law in respect of a range of different jurisdictions, some of them far less democratic than others. And so I think there will be, in a range of ways, a big discussion going on at the international level about the need to resist the use of the criminal law in the kind of coercive element of the pandemic. But I think the key issue will be the structures of constitutional accountability and transparency around scientific knowledge, because the whole human rights regime, which depends on balancing and proportionality to work, is it's incapable of actually operating properly unless it's underpinned by real evaluative scientific knowledge in respect of why we might be taking these limitations. So in the convention context, all of the questions around limitations of liberty, whether it's within the context of a derogation or not, all of that will require very specific knowledge. And the question is, whose expert knowledge, how is it formulated, and whether we can keep it away from partisan political objectives. And so we've seen this debate, assumptions, general debate about how we're all being treated like children in this country. This question of the balance between liberty and life, I think, will be absolutely essential to the debate as it moves on, but particularly the underpinning structures for how we make those choices and how policy gets defined in the light of scientific advice. And that is a constitutional question, I think, for many countries, is how to keep scientific advice and knowledge independent of political influence.
Thank you, Leora, and of course, fundamental questions have been asked about the independence of the relevant scientific committee in the UK, and evidence that seems to suggest that there has been a willingness from part of government to influence their judgments. There have been interventions anyway that were moving in that particular direction. On that note, we were supposed to finish this lecture about half an hour ago, and I think it's a very positive sign. Though I have to apologize to all those of you that had to stay longer. I want to express my gratitude, my thanks to all that have participated. Leora Lazarus, Kirsty Brimelow from the part of the UK. And of course, Professor Andrea Roth and Professor Charles Weisselberg. We are very privileged. We are delighted for your contributions. Thank you very much for delivering the second annual Criminal Justice Lecture of Goldsmiths Law. And we very much wish to make a legacy out of this. We hope that we will continue to be in contact and are very much looking forward to having this conversation about issues that are fundamental to us and issues that are fundamental to you, and they relate to equality and the rule of law and international human rights and constitutional rights. Again, thanks everyone for your invaluable contributions, and we look forward to connecting with all of you again soon. Thank you.
Thanks a lot.
Thank you very much. Bye.
Thank you, everyone. Thank you. Bye-bye. Thank you.